Terry versus Ohio. All roads lead back to this case. In closing, all I want to do is read to you the lone dissent in the case of Terry versus Ohio because it was beautifully written by Justice Douglas. He says, I agree that petitioner was seized within the meaning of the Fourth Amendment. I also agree that frisking petitioner and his companions for guns was a search, but it is a mystery how that search and that seizure can be constitutional by Fourth Amendment standards unless there was probable cause to believe that 1, a crime had been committed, or 2, a crime was in the process of being committed, or 3, a crime was about to be committed. The opinion of the court disclaims the existence of probable cause. If loitering were an issue, and that was the offense charge, there would be probable cause shown. But the crime here is carrying concealed weapons, and there is no basis for concluding that the officer had probable cause for believing that that crime was being committed. Had a warrant been sought, a magistrate would therefore have been unauthorized to issue one, for he can act only if there is a showing of probable cause. We hold today that the police have a greater authority to make a seizure and conduct a search than a judge has to authorize such action, when we have said precisely the opposite over and over again. In other words, police officers up to today have been permitted to effect arrests or searches without warrants only when the facts within their personal knowledge would satisfy the constitutional standard of probable cause. At the time of their seizure without a warrant, they must possess facts concerning the person arrested that would have satisfied a magistrate that probable cause was indeed present. The term probable cause rings a bell of certainty that is not sounded by phrases such as reasonable suspicion. Moreover, the meaning of probable cause is deeply embedded in our constitutional history. As we stated in Henry versus United States, the requirement of probable cause has roots that are deep in our history. The general warrant, in which the name of the person to be arrested was left blank, and the writs of assistance against which James Otis inveighed, both perpetuated the oppressive practice of allowing the police to arrest and search on suspicion. Police control took the place of judicial control since no showing of probable cause before a magistrate was required. That philosophy, rebelling against those practices, later was reflected in the Fourth Amendment, and as the early American decisions both before and immediately after its adoption show, common rumor or report, suspicion, or even strong reason to suspect was not adequate to support a warrant for arrest, and that principle has survived to this day. It is important, we think, that this requirement of probable cause be strictly enforced, for the standard set by the Constitution protects both the officer and the citizen. If the officer acts with probable cause, he is protected, even though it turns out that the citizen is innocent. He's given us a precursor in this opinion to qualified immunity, by the way. Just pay attention. And while a search without a warrant is, within limits, permissible if incident to a lawful arrest, if an arrest without a warrant is to support an incidental search, it must be made with probable cause. Now pay attention to what he's saying here. This is 1968. This immunity of officers, he's referring back to what he said a few seconds ago. If the officer acts without probable cause and it turns out the citizen's innocent, he's protected. He's talking about the officer being immune from suit if he makes an arrest on probable cause, but he's wrong. So he's going back, and he says this immunity of officers cannot fairly be enlarged without jeopardizing the privacy or security of the citizen. So he's basically saying that by carving out a new place for officers to hang out, reasonable articulable suspicion, you're expanding their immunity to include reasonable articulable suspicion. And that can't be done without jeopardizing the privacy or security of the citizen. And my goodness, is that ever true today? Back to his quote, the infringement on personal liberty of any seizure of a person can only be reasonable under the Fourth Amendment if we require the police to possess probable cause before they seize him. Only that line draws a meaningful distinction between an officer's mere inkling and the presence of facts within the officer's personal knowledge which would convince a reasonable man that the person seized has committed, is committing, or is about to commit a particular crime. In dealing with probable cause, as the very name implies, we deal with probabilities. These are not technical, they are the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. act. This section is so powerful. To give the police greater power than a magistrate is to take a long step down the totalitarian path. Perhaps such a step is desirable to cope with modern forms of lawlessness,